Hello, Emily. Nice to see you.
Nice to see you, Emily.
So today the Canadian Association of Elizabeth Fry Societies intervened at a case at the Supreme Court of Canada with your help as our counsel. And we wanted to have a discussion with you about that intervention and a little bit about what it means to be intervening at the Supreme Court and what our argument was. So before we begin, I was hoping you could just introduce yourself and where you work.
Okay, hi, my name is Emily Tamman. I'm a lawyer practicing employment and human rights law with Champ and Associates in Ottawa.
Incredible. And you are somewhat notorious lately because of the work that you were doing in Ottawa around the noise that came from the Freedom Convoy in front of Parliament.
That's right,
You have
yes.
been busy. You have been busy. And in amongst all of that, you also were preparing for this intervention at the Supreme Court. So can you tell us a little bit about this case?
Absolutely. So we were intervening in the case of R versus Sharma. This was a case involving a young Indigenous woman who pled guilty actually to an importation of drugs offense. She was a young woman, a single mother, experiencing an enormous amount of economic hardship, was on the verge of losing her housing, was at risk of losing her child as a result of that, and ended up succumbing to an irresistible offer to travel to the Caribbean and return with a quantity of cocaine. She was approached at customs when re-entering Canada. She immediately confessed to what she had done. She pleaded guilty at an early opportunity. And the trial judge, in trying to determine what a fit sentence would be for Ms. Sharma, faced a number of barriers to imposing a fair and equitable sentence. The first was the existence of a mandatory minimum jail sentence that applied for the offense she was convicted of. And the court actually found that the mandatory minimum was unconstitutional and declined to impose it. So that was a really positive first step. The judge considered, as all judges do in sentencing people that have been convicted of crimes, aggravating factors and mitigating factors. So sentencing is a very individualized process. It requires the judge to consider not only the seriousness of the offense, but the circumstances in which the offense was committed and the circumstances of the offender. And considering, factors that make it more serious, factors that mitigate the moral blameworthiness of the accused, to come to a sentence that is appropriate and fit. In the case of Ms. Sharma, the trial judge concluded that an appropriate sentence would be what's known as a conditional sentence of imprisonment. So that is where a judge concludes that jail is the appropriate range of sentence, a jail sentence is appropriate, but that concerns about public safety and other related issues are not particularly acute, and that therefore the person could serve their sentence in the community. So a conditional sentence is basically typically like a house arrest type of sentence. So, and this can be particularly important for people like Ms. Sharma because it allows them to maintain, first of all, a connection to their children, because if they're to be incarcerated, they would then be separated from their children, but also maintain a connection with their community and have access to supports and programs that can contribute to the person's rehabilitation and reintegration into society. However, in 2012, there were amendments to the criminal code that took away the availability of conditional sentences for certain types of offenses. And there were two sections of the code in particular that created obstacles to Ms. Sharma getting the conditional sentence that the judge felt would otherwise be fit and appropriate for her. The first was a provision of the code which holds that conditional sentences are not available upon conviction of an offense with a maximum punishment of up to 14 years. And conditional sentences are not available for importation of drug offenses where there is a maximum penalty of up to 10 years. And so, I mean, it's interesting, right? Because these are very significant penalties, 14 years, 10 years. And yet in Ms. Sharma's particular circumstances, the judge was of the view that 18 months would be appropriate. So she was nowhere near approaching those, really high level sentences, which would be reserved for, the most serious offenders in the most serious circumstances. However, because of those provisions of the code, the judge was of the view that a conditional sentence couldn't be imposed. Now, what was really interesting in this case, and which is kind of unusual actually at the trial level, is that Aboriginal Legal Services, an organization based in Toronto, intervened, and we're going to talk a little bit more about what intervening means, but at the trial level, which is very rare, and helped Ms. Sharma and her counsel build an evidentiary record and put a case before the trial judge to argue that those provisions of the code that limited the availability of the conditional sentence should be found to be unconstitutional because under sections 15 and 7 of the charter, so section 15 being the right to equality before and under the law, it was argued that these provisions were discriminatory because of the ways in which they contribute to the over-incarceration of Indigenous people. And secondly, under section 7 of the charter, which protects the right to life, liberty, and security of the person, and not to be deprived thereof, except in accordance with the principles of fundamental justice. It was argued that the provision was overbroad because Parliament's purpose in enacting those provisions was to make sure that people who commit the most serious offenses get jail sentences. And they argued that someone like Ms. Sharma actually didn't commit a really serious offense. It was at the very lower end of seriousness for drug importation offenses. The trial judge rejected that though and imposed an 18-month custodial sentence on Ms. Sharma. To her credit, even though she'd already served her sentence and she had nothing to gain by pursuing an appeal, she did appeal that decision because it was felt that the legal issues were incredibly important, and given the substantial evidentiary record that had been put before the trial judge, that the matter should be pursued further. And so it was appealed to the Court of Appeal, and a majority of the members of that court agreed that those provisions were unconstitutional, both under section 7 and section 15 of the charter. And I just want to point out, because I think it may not be intuitive to a lot of people, but in the context of criminal law, it's actually quite rare for the equality protections in the charter to be successfully invoked to challenge criminal legislation. So this was a really impressive accomplishment on the part of Ms. Sharma's counsel before the Court of Appeal. And unfortunately, the federal Crown decided to appeal that decision, felt that the Court of Appeal got it wrong, that the provisions were not unconstitutional, that the Court of Appeal unduly interfered with Parliament's discretion to decide, about matters of law and punishment. And so they appealed to the Supreme Court of Canada, and that's how we found ourselves there today.
Amazing. That was really a great comprehensive overview, and I think a lot of people will appreciate that. And so here we are at the Supreme Court, and even at the appeal level, and sometimes at the trial level, organizations and individuals who have an interest in the proceedings can apply to become interveners. And so the Canadian Association of Elizabeth Fry Societies decided that we definitely had a stake in this, given the work that we do with criminalized women and gender diverse people, and particularly because of the over-criminalization, the over-surveillance, over-criminalization, over-incarceration, and then, over-punishment of Indigenous women and gender diverse people once they go to prison. And so that reality that we see every day in the work that we do at the local level with the Elizabeth Fry Societies and at the national level prompted us to seek intervener status. And so that's when you and I had a conversation about whether or not you would be interested in being our counsel. You said yes. We're very lucky that you did. And so can you tell us a little bit more about that? What is an intervener? How do you get to be an intervener at these cases?
So because the Supreme Court is making, final decisions on matters that often implicate, important public policy issues, constitutional issues, there is a mechanism that allows interested parties who have a particular expertise to bring to bear that could be of assistance to the court, not necessarily just in resolving the particular legal dispute that's an issue. So not necessarily just on the question of, what sentence should Ms. Sharma personally have received, But just as you described the experience that CAFES has, that was experience that we felt would be important for the court to be aware of, right? And what was really exciting about this case actually was the vast numbers of parties that applied for and were granted intervener status, many of whom had, intersecting and yet unique perspectives to bring to bear on the issue. So you're not automatically entitled to appear at the Supreme Court as an intervener. You have to first bring a motion seeking leave to intervene. And in that process, the parties have to make the case to the court that they have that experience, that expertise to bring to bear, perhaps as is the case with the Canadian Association of Elizabeth Fry Societies, having intervened in other cases, and really just making the case that you also bring something extra. So the court's not interested in having interveners come and just reiterate the positions of one or the others of the parties. It's not a way of sort of consolidating the arguments that one of the parties wants to make, but to actually kind of bring something new to the discussion. And what's kind of exciting when you're acting for an intervener rather than a party is that you can be pretty like outside the box in terms of the types of proposals that you're making. And I think in some ways that's what we were able to do today. Planting seeds, that might not necessarily take root and be determinative of the issues in this case, but that are kind of pushing the court and asking the court to push Parliament, in the context of this case anyway, to really think about the ways in which governments have been falling short in failing to adequately address the crisis of over-incarceration of Indigenous women and Indigenous people generally.
Yeah. And so, CAPES was one of, as you mentioned, many interveners today. And I wondered if you could describe to people, because you only get 5 minutes as an intervener to present your oral argument, even though you're able to and you have to submit a written argument ahead of time. So you don't get a lot of time, right, with your 5 minutes. So could you use some time now to just tell us what our argument was?
Absolutely. So, what was pretty nifty about this whole process actually was that all of the interveners who had been granted standing to make submissions took some time in advance of the hearing to check in with one another on what types of arguments we were planning to bring forward to, increase the likelihood that as many arguments would be made. And we did that even prior to applying for leave, because we wanted to make sure that we were all able to show that we brought something, unique and different to the table. So, some parties focused very heavily on the role of Indigenous law and Indigenous traditions and how the courts need to respect that, and how unduly interfering with Indigenous women's ability to perform their roles within, within Indigenous traditions, for example. So there were some Indigenous-led organizations that were making arguments like that. What was of interest, I think, to us was to ask the court to look at the relationship between the right to equality on the one hand under Section 15 of the Charter, and the right not to be deprived of your liberty except in accordance with the principles of fundamental justice. So typically in these cases, the question of equality and the question of deprivation of liberty are dealt with in two separate kind of analytical silos. And there's a very well-established test that applies to both of those. But in some ways, I think we felt in our discussions that it was sort of imperfect and it missed an opportunity to have the court think a little bit about developing a framework that recognizes that there are dual harms that come from being subjected to a system that has been so well established as being imbued with systemic discrimination, particularly vis-a-vis Indigenous persons. So there's the fact that you're being discriminated against, and there's the fact that you're having your liberty taken away through incarceration. And so under the traditional way that a court would look at this, they would just ask, is the provision discriminatory? And then would separately ask, is the deprivation of liberty in accordance with the principles of fundamental justice or not? And I know that sounds, sorry for people who aren't lawyers, like, what does that even mean? Like, in accordance with the principles of fundamental justice? And essentially, for the purposes of this discussion, it means that Parliament may have a particular purpose in enacting a law, But in giving effect to that purpose, it cannot rely on legislative measures that are overbroad. So as I described before, that might capture people who aren't really properly captured by Parliament's purpose. So serious offense, jail. Well, this offense can be committed in a wide range of ways. And it was argued successfully before the Court of Appeal that, in fact, in Ms. Sharma's case, it wasn't really a serious offense, at least not necessarily in the way that Parliament intended when limiting the availability of conditional sentences. So is the provision overbroad? Is it arbitrary in that it bears no connection to Parliament's purpose? Or is it grossly disproportionate? So it offends Section 7 of the Charter to essentially mandate that judges impose sentences that are grossly disproportionate to the seriousness of the offense. And so what we were suggesting was that in considering those issues, and in particular the question of proportionality, the court should, and sentencing courts should, consider the discriminatory context, i.e. criminal justice institutions, and that should sort of elevate concerns under Section 7. So under the criminal code, sentences have to be proportionate. So proportionality is a fundamental principle of sentencing, but constitutionally, it's only grossly disproportionate sentences that are prohibited. And so what we argued is that the court should consider that if all that would result is a disproportionate sentence and not a sentence that is grossly disproportionate, but it arises in a discriminatory context, like that makes it gross. Like that's basically how I even worded it in the leave application. Like proportionality that arises in a discriminatory context is by its very nature gross.
Right.
So it's a little like technical and legal, sorry, but we just felt that it was really important because, as I said before, traditionally courts have not really attacked the equality guarantee component when dealing with criminal law. And I think it's partly because it's not really the bread and butter of criminal lawyers. It's not really the bread and butter of criminal jurists. And so it's always been more comfortable. Sorry, I'm just gonna let my dog.
Sure.
Well, just excuse me for a quick minute.
Go.
So yeah, so basically, because these issues are not really within the bread and butter of criminal lawyers and criminal jurists, it's always just been more comfortable to resolve these issues under Section 7. And as a result, the court's jurisprudence, or the body of case law that gives direction to lower courts, hasn't really grappled very meaningfully with the equality dimension. And what's surprising about that, and which I pointed out to the court today in the submissions, is that actually the Supreme Court has on many occasions used very, very strong language to describe the systemic discrimination that Indigenous people encounter in criminal justice institutions. And yet it's made those pronouncements in cases that didn't even really invoke Section 15 of the Charter or the equality guarantee. And so we were kind of saying, just take in a more formal way, incorporate those concerns about the discriminatory context without necessarily making accused people go through all the hoops to the very formalistic and technical approach that courts take to Section 15. Let's just accept that because of the government's direct intergenerational implication in the systemic disadvantage that Indigenous people face today, not only in criminal justice system institutions, unfortunately, but on many other aspects of their ability to participate fully in society. Because the government's so directly implicated in that, it doesn't make sense, and it isn't fair or even necessary to make rights claimants go through the hoops of showing that this particular criminal code provision causes an increased likelihood of incarceration. We said, let's just say, if it takes away a non-custodial option from the kind of menu that a sentencing judge has in considering how to sentence a person, like, let's just say that that contributes to over-incarceration at a time when governments should in fact be looking to legislate in ways that tackle that problem and reduce over-incarceration. These types of provisions, unfortunately, increase it. And what was really disheartening was that the Crown was kind of arguing, well, they don't have data that bears out that after these provisions came into effect, that there was a disproportionate increase or a decrease in conditional sentences. And it just was so kind of unseemly in a way. It's like, you accept that there's systemic discrimination, you accept that the government's responsible for it. Like, don't put this burden on rights claimants. And as you know, Emily, charter rights are subject to reasonable limits. So Section 1 of the Charter provides that even if a court does find that a provision breaches the Charter in some way, it might still be reasonably justified. And if the government can show that it's reasonably justified, then the provision is saved and it's not unconstitutional. And that's mostly because in some cases you have two competing rights that come into conflict with one another. So
Right.
someone's freedom of religion versus someone's freedom of speech or something like that. And that it's inevitable that the government will have to curtail, or the ways in which free speech is subject to limits, when it comes to hate speech, for example, right? That's the courts have found that to be a reasonable limit that Parliament has imposed on the otherwise wide open guarantee of freedom of expression. And so what some of the other parties in particular were arguing was that when you're trying to establish a breach of the charter, the onus is on the claimant. So the onus is on the person who's saying their rights have been violated. What was being argued today was that really more of that burden should be shifted onto the government, given its historical implication in this, really pernicious problem. And so don't make the claimant go through a million hurdles. Like, let's just accept that there's discrimination and it's been caused by the government in many different ways. And if they want to implement, legislation that is going to contribute to rather than reduce over incarceration or just incarceration generally, then put it to them to bring the evidence to show that it's justified. They have so many more resources. So it's kind of an access to justice issue, I think, in a lot of ways.
Yeah. Wow, wonderful. I think people really will appreciate your analysis. And do you know when we will hear from the court? Is there an idea of when we might get a decision?
Not really. It could be weeks, months, years. I
And
don't think
so
it'll be
we
years.
wait and we wait and we cross our fingers and our toes.
Yeah, I mean, and what we had going for us was that, we were there, but there were, every single non-attorney general party today was all on the same side.
Yeah.
There wasn't a single intervener who wasn't an attorney general arguing that these provisions should stand or that
Right.
they hold up to charter scrutiny. So, and there were 19 such parties, right? So
It is really remarkable.
yeah, so I think, a very, very persuasive case was made. And if it wasn't successful in this case, it will certainly have put some building blocks in place that will be able to be, unfortunately, incrementally kind of built upon in future cases. But I'm going to, like you, cross my fingers that we actually managed to persuade the court here. A kind of weird little dimension of all of this is that there is a bill currently before Parliament that would repeal both of these provisions. So, which makes it even weirder that the government was there arguing, that they're not unconstitutional, but at the same time, they've acknowledged that they should be repealed. So whatever happens here, we can hope that at least this little slice will be dealt with legislatively, if not by the courts. But we still feel it's really important to get this precedent out there and to get the court to grapple more, with these issues. So hopefully we'll see that happen.
Wonderful. Well, thank you. And on that note, we will stop and we will hopefully see you again at another intervention for CAFES.
Sounds good.
Thank you. Bye, Emily.